सलाम, आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना है जो भारतीय संविधान ने उन्हें दिए है। अगर आप हमारे चैनल पर पहली बार आए हो तो कृपया इसे सब्सक्राइब करें और बेल आइकन को क्लिक करके सबको चुने ताकि जब भी हम नए वीडियो अपलोड करते हैं तो आपको उसकी सूचनाएं मिलती रहे। हमें बहुत खुशी होगी अगर आप इस वीडियो को अपने संपर्क और दोस्तों के साथ साझा करें। Hello everyone, I am Advocate SULAIMAN BHIMANI and I welcome you all to the Citizen Justice Forum video channel. Our mission is to empower Indian citizens by sharing knowledge about the fundamental rights which is being given by the Constitution of India. If you are watching us for the first time, don't forget to subscribe and click the bell icon and select all so you get notification whenever we upload a new video or we go online. Friends, it would be greatly appreciated that if you share this video with your friends and contact. आज मुझे बड़ी खुशी हो रही है कि आप सब यहाँ हमारे साथ जुड़े हुए एक बहुत ही इम्पोर्टेंट सेशन के लिए। 1 जुलाई से हमारे देश में 3 नए कानून लागू हो गए हैं और इसकी चर्चाएं बहुत ही हो रही है जो हमारे डेली लाइफ और हमारे अधिकारों पर बहुत बड़ा असर डालेंगे। आज हमारे बीच में एक बहुत ही रिनोन्ड एडवोकेट और गवर्नमेंट लॉ कॉलेज के प्रोफेसर है। उनका वास्ट एक्सपीरियंस और नॉलेज हमें इन नए कानून को समझने में मदद करेंगे और बताएंगे कि ये आम नागरिक के कैसा इम्पैक्ट करेंगे। आज हम जिस नए कानून पर चर्चा करेंगे वो है भारतीय नागरिक सुरक्षा संहिता, जिसको हम पहले सीआरपीसी बोलते थे। ये लॉ इंट्रोड्यूस किया गया है। द न्यू कोड introduces stricter provisions for bail and demand, ensuring that serious offenders are not released easily while under trial, thus enhancing public safety. इस लॉ के इम्प्लीमेंटेशन से बेल और एबीए मिलना मुश्किल हो जाएगा। BNSS includes special provision to protect vulnerable sections of society such as women, children and the elderly, जो senior citizen है। This includes dedicated procedures and fast-track courts for crimes against these people. यानी अगर बच्चों के खिलाफ या ज्येष्ठ नागरिक के खिलाफ या हमारी महिला के खिलाफ कोई क्राइम होता है तो उसके जो न्याय की जो प्रतिक्रिया है वो फास्ट ट्रैक पे चलेंगे। और दूसरा जो हुआ है आईपीसी, जिसको अभी हम कहते हैं भारतीय न्याय संहिता। इस लॉ का एम है there should be harshest penalty for serious offenses such as rape, murder and terrorism. This serves as a deterrent and ensures that perpetrators of the grave crimes face severe consequences, enhancing public safety. और ये लॉ लेकर आता है डिजिटल एविडेंस। यानी आज की तारीख में हम सब लोग मोबाइल यूज करते हैं, आईपैड यूज करते हैं, कंप्यूटर यूज करते हैं, लैपटॉप यूज करते हैं। तो ये सब जो डिजिटल ट्रांजैक्शंस भी होता है, बहुत से लोग का ऑनलाइन चीटिंग होती है। तो ये डिजिटल एविडेंस किस तरह से उसको कलेक्ट करना है और किस तरह से उसको कोर्ट में पेश करना है ताकि उसमें कोई लूप होल्स ना रह जाए जिसके अक्यूज को फायदा पहुंचे। The importance of digital evidence and outlines procedure for its collection, preservation and presentation in the court. The victim compensation enhances mechanism for timely and adequate compensation to victims of crimes. Their implications for the general public. अभी नया लॉ जो है, जो भारतीय साक्ष्य अधिनियम है, दैट इज जिसको हम पहले हम आईपीसी बोलते थे, राइट। अभी ये इसके अंदर क्या सुधार है? ये लॉ एविडेंस के एस्पेक्ट को रिवैम्प करता है और इसका aim है to recognize and integrate digital evidence into legal framework. This includes guidelines for the admissibility, collection and preservation of electronic records, which is crucial in the era of the digital transactions and communications are commonplace. In changes, the modernized rules of evidence provides better protection for individuals' rights and ensuring that evidence is handled fairly and justly. This reduces the risk of wrongful convictions and other miscarriage of justice. अब बिना किसी देरी के मैं आप सबसे रिक्वेस्ट करता हूं कि हमारे एस्टीम स्पीकर को मोहम्मद अफजल, जो हम प्यार से उनको आमिर खान बुलाते हैं, वो हमारे स्पीकर का परिचय दे और ये इवेंट और ये प्रोग्राम और ये वीडियो को आगे बढ़ाए।
आज के हमारे वरिष्ठ स्पीकर जो है एडवोकेट प्रॉस्पर डिसूजा, इन्होंने BA-LLM किया हुआ है। इन्होंने DLL जो लेबर लॉ होता है उसमें उन्होंने काम किया है। उन्होंने डिप्लोमा इन साइबर क्राइम किया है। He has been a professor in the government law college for the last 22 years and ये एक practicing advocate है बॉम्बे हाई कोर्ट में for the last 25 years. He is arbitrator and he is an arbitrator on the government panel in the Bombay High Court. और मैं चाहूँगा कि आज ये बहुत important subject है और इस पे ये अपना प्रतिक्रिया दे। Over to you.
Good evening to all of you all. Slight correction, rather than correction, I would say I may not have got across my CV properly to the organizers here. I am a visiting faculty in Government Law College and I've been teaching law over the past around 21-22 years in various law colleges. And I am an arbitrator and a mediator on the panel of the Honorable High Court. Let's begin, because all of you all might be patiently waiting for what these new laws are all about. As Senior Advocate BHIMANI sir already told you all, that this old name of Indian Penal Code, now rather than just the name, the whole law itself, wherever changes were required, those changes have been made in that Indian Penal Code. And now that Indian Penal Code 1860 is now known as Bharatiya Nyaya Sanhita. Nyaya Sanhita. Now, initially I will just briefly tell you all what this new law is all about. Later on I will take you all a little more deeper into what this new law brings with the changes, and then maybe if time permits we'll go much deeper into few sections here and there, depending on how much time we are able to dedicate to each of those sections. Now, my opening comment is that this new law has kind of consolidated and streamlined various provisions. Consolidated is to bring together various provisions and streamline the provision as such. Let me actually say what I mean. Now this, let's say for example, the definitions, they were scattered especially from section 1 to around section 53, and even beyond that in some of the other sections also, they also contain definition. Now all these definitions are brought under section 2. And not only that, they have also put them alphabetically. Initially it may sound a little inconvenient to make that switch from the old law to the new law. As far as the numbers are concerned, there was a requirement to renumber those sections, because if you have to put something in order, then shifting them to some other slot was necessitated, and that has been done. The number of sections were 511, now it is reduced to 358, and provisions of offences against women and children, they have been brought together under one roof, which is chapter 5. So all of them have been clubbed together and brought together and put under chapter 5, thereby simplifying the legal framework. The whole purpose, the whole intention of the legislature is to simplify the legal framework. Then, going to another point, I'm briefly touching about various points, as I said at the outset. The language which is used is a modernized language. As we go along, when we talk about not only this act, but the other two laws also, you will see that some words were archaic, they were outdated, or rather they needed to be replaced with the modern language. That has been done. So also with the definitions. So outdated and colonial language has been removed, and there is some kind of uniform terms have been adopted. For example, the term minor, that has been replaced with the term child. The term insane has been substituted with the phrase person of unsound mind. There's a purpose behind all this. As we go along, we will see. We'll try and understand more of all this. Also, there is this expanded jurisdiction in this new law called Indian Penal Code. If you visit section 48 of this new law, you will find that it has extended jurisdiction to criminalize abatement. Abatement, you're provoking, you're kind of instigating, all of that, which is already defined in the old law as well. But then this jurisdiction, by virtue of this section 48, has been extended to criminalize abatement outside India, and thereby broadening the legal scope of the legal enforcement as such. So a person could be conspiring or abating some crime from outside the shores of India, and he also can be brought within the four corners of this law. That was the whole purpose. Now there are also revised offences as far as the property is concerned, against property. For example, the definition of theft has been expanded to include theft of data. Data is a new oil, they say. The saying also has become quite old now, quite time. And of late we have the data protection law as well. Now this theft of data, or be it identity theft, which many of us may have fallen prey to, or be it theft of intangible assets, okay, all that has been brought within the definition of theft as such, specifically and purposefully. Also, snatching has been introduced as a distinct offence under section 304 of this new law called Bharatiya Nyaya Sanhita. Then there is a new section incorporated, which is all about mob lynching, a very much required section. Before this new law could come into place, mob lynching was not a separate offence as such. Now, under this section 103, subsection 2 of this new law, it introduces this mob lynching as a serious category of culpable homicide. You're taking away the life of somebody, you're coming together, and you're taking away the life of somebody. That is viewed very seriously by this new law, and therefore the need for this new section called mob lynching, which is 103, subsection 2. There are also new categories of offences introduced in this new law. For example, this organized crime, then petty organized crime. They are central offences for the first time under section 111 and 112 of this new law. And this Terrorist Act as such also has been brought under this new law, and it is there in section 113 of this Bharatiya Nyaya Sanhita. Then again, this attempt to commit suicide, that has been deleted from this new law, keeping in line with this Mental Health Act, Mental Health Care Act 2017 as such. When you talk about sedition, there are a lot of discussion on this provisions of sedition law, which was there initially in section 124A of Indian Penal Code. And that law, it seems, it suppressed constitutional rights, and therefore it has been deleted from this new law called Bharatiya Nyaya Sanhita. And instead, the acts which excites or attempts to excite, or succession or armed rebellion, or subversive activities, or separatist activities, or this is now what I'm going to say are very important words, or endangering the sovereignty or unity or integrity of India, they have been dealt with under section 152 of the Bharatiya Nyaya Sanhita as such. Then there are revised punishments, and that amongst the revised punishment, which is now incorporated in section 4F to be precise, it incorporates a new punishment called community service. Now, it is introduced as a punishment for certain offences, and the whole approach is a reformative approach. You look at a criminal from the lens of a reformative theory as such. So that is aimed to achieve nyaya in the society. Nyaya means justice. So it is not just a change of word from Indian Penal Code, Bharatiya Nyaya Sanhita. As we go along, you will see there is nyaya for everybody. There is justice for all the stakeholders as such. That is the endeavor of the legislatures. So also, this sexual intercourse on false promise to marriage. That has been specifically made an offence under section 69 of the Bharatiya Nyaya Sanhita. No? And it penalizes sexual intercourse on false promise of marriage or by employing deceitful means. Believe me, had it been before this new law could come into place, it was really difficult to show that there were false promises and people would get away. Now, somebody who purposefully deceive someone and commit some sexual offences by giving false promises of marriages, he is in for trouble. So this is in a way protecting the rights of the citizens as such. Then as you go further, you will see, I'm just talking very briefly about so many laws, then we come to specifics. These laws can be claimed to be gender neutrality. The gender neutrality aspect may not have come across throughout this new law, but it is surely incorporated, it is surely there, no? In a very conspicuous way. As far as assault or use of criminal force to a woman with intent to disrobe and voyeurism, they have been made gender neutral under the section 76, 77 of this new law. Then the offence relating to the importation of a person from a foreign country, that has also been made gender neutral to cover both boys as well as girls in section 141 of the Bharatiya Nyaya Sanhita as such. This is a brief of Indian Penal Code, and immediately I will go on to the another law just to give you some bullet points about all three laws. One, I have already told you some points here and there. I will go on to another law, which is replacing the old Code of Criminal Procedure Code 1973. The new name for this Criminal Procedure Code 1973 is the Bharatiya Nagrik Suraksha Sanhita. So if you understand a little bit about this Hindi or somewhat of Marathi, you would understand what these words mean. You know, they are indigenous words. Bharatiya Nagrik Suraksha. The title itself of this new law is claiming to give you some kind of protection, and therefore it will be justified as you go along to various provisions which are there in this new law as such. So now, as far as this new law, the old one being Criminal Procedure Code, the new one being Bharatiya Nagrik Suraksha Sanhita, as far as this new law is concerned, you'll find there are changes made in the definitions also. This audio, video, electronic, this definition is there, section 21A. Then you see the bail, definition of bail is also, you'll find section 21B. Bail bond is also defined in section 21D. So also bond is defined in 21E. And also the much needed electronic communication, that is also defined in 21E. And I know you all may not be able to memorize the section numbers that I'm quoting, but then somewhere it would be helpful as we go along when we talk a little more about the section. It will be really useful to get to know what those sections really mean, how that terminology is really defined. Now these new terms have been introduced, okay, and it reflects the evolving landscape of technology, no? When it comes to investigation, when it comes to trial, when it comes to court proceedings, covering various aspects of service of summons as well, of notices, of audio-video conferencing, for deposition of evidence, recording of search and seizure, all this got covered under this. I mean, this new definitions are really helpful to bring in all these new changes, which were much awaited and much needed changes, which have been brought about through this new law. Now there are procedural changes as well. As far as proceedings which are committed are concerned, they have to be finalized within 90 days from the date of taking cognizance. Cognizance is really you take notice of that offence and you initiate the process, and all it entails all that. Now this 90 days could be max extended up to 180 days, and also supply of copy of the police report to the accused and the victim within 14 days of the date of production or for appearance of an accused. That provision is also made. So accused gets a copy, victim gets a copy, they know what the proceedings are all about, they know what they are in for, so they are not ignorant about what is happening. So also section 37, subsection 7 of this new law, it prohibits arrest without permission of an officer above the rank of DSP. In cases where the offence is punishable for imprisonment for less than 3 years, and if the person to be arrested is an infirm or is above 60 years of age, then you need the permission of DSP, only then you can go ahead and arrest such a person. Under section 107 of this new law again, there is that attachment, forfeiture, restoration of proceeds of crime. All these things have been incorporated, they have been introduced in this new law as such. As far as use of handcuffs is concerned, that was felt necessary by the legislatures, and therefore a provision to that effect has been made in section 43, subsection 3 in this new law. And it is newly inserted to provide the use of handcuffs while effecting the arrest and production of an arrested person before the court for certain offences. Now this also can be justified. Of course, any law that I'm talking about, any new introduction, any change, you could argue both ways. But believe me, the intention of the legislatures is that all stakeholders should benefit, and the law machinery should work in such a way that there is justice done. That is the whole endeavor of incorporating or introducing these changes as such. There will always be a resistance to whenever changes are made. But as we go along, as the law settles, and if at all there are any challenges, there would be perhaps, those also would come, there would be ironing out of those creases by the judiciary from time to time, and that would take care of the law, whatever changes have come about. If at all there's any controversy raised about any provision. There is a provision about zero FIR also. Certain provisions are not new, they were always there. Earlier also, if you were to file a FIR in some police station which does not have jurisdiction, then they would have to forward it to the concerned police station. Those conceptually, those things were there. But now, in a formal way, they are incorporated. And by doing such a thing, by formally incorporating such provision, there comes about a lot of clarity, and any misconception around such concept, those get removed, and people would benefit from that. There may have been a reluctance on the part of the authority to register zero FIR earlier. That may have been the experience of some people. But now, this new law having made these things clear, I don't think anybody would dare to hesitate to take a FIR. Okay. FIR is just a first information report. It is setting the machinery of law in motion as such. No? And it is kind of a mandate given to the Law Machinery Enforcement Authority to register that zero FIR under 173 of this new law. Then there is a provision about mercy petition also. If you look at 472 of this new law, criminal law, this time-bound disposal of the mercy petitions in death sentences have been introduced. Now, I would go to the extent of saying it's not the right thing to keep somebody waiting forever and letting him not know his fate as to when he would be taken to the gallows. His mercy petition is pending and he doesn't know what is done to that mercy petition, when the mercy petition would be decided. But now with timelines in place, that is one new best thing, good thing that has happened with this new law coming in. There are timelines, within certain time something has to be done, and ultimately such matters get disposed of timely. That is again a good thing. They even looked at it from the accused point of view or the convict point of view as such. Then, as learned advocate BHIMANI also said, there is this witness protection scheme also. No? There is this section 398 which allows or enables or empowers the state to come up with a witness protection scheme. How is this helpful? As of today, we are all aware that any of us, if we are called to give witness in the court of law, we will be the last person perhaps to volunteer or come forward and help the police machinery. With the result, if you don't have the right witnesses coming forward, those who have actually seen the offence or those who could help in the bringing justice, they may not cooperate, and then there will be that problem of delivery of justice. Now, if the state government, when it comes up with the right scheme, which would be allaying the fears of people, and thereby they would be encouraged to come forward as witnesses, that would really be a good thing as such. Then, as I said earlier, in that Indian Penal Code, the new law, Nyaya Sanhita, there also gender neutrality has been brought about. Here also, if you see, there was this phrase called some adult male member that has been replaced by some adult member for the purpose of service of summons. Earlier, one had to serve summons to adult male member only. That was really discriminatory and not the right thing perhaps, and that needed to be replaced, and that has been done with the incorporation of this section called section 66 of this new law. Then you could say, with this coming of this new law, this procedure has met technology. Met as it, technology was going ahead, at a fast pace, and the procedure wasn't moving at that pace or coping up with the advancement of technology. that seems to have happened with this coming of the new law to a great extent. So, in order to ensure the use of technology and to bring about accountability in this investigation during search and seizure, what has been done is Section 105 of this new law. They have made videography of that process of search and seizure, including preparation of a list of seized items and the signing of it by witnesses, mandatory. Recently, I had one case where one lady was saying the police have not taken proper stock of the item that were there in the house, and some of it has got pilfered, and she was blaming everybody left and right. Now, all that perhaps would be settled with this coming of this new law when you have videography done also. Whether this is foolproof or not, that only time will tell. The other day I was discussing this provision with some colleague advocate, and he happened to say it also may so happen that they may visit that place beforehand, and they may put things in a certain order or tamper with the evidence, and thereafter the videography may happen. If at all any such things happen, then it is for the person who is defending that accused to bring it to the notice of the court, or the prosecution to bring it to the notice of the court, and the truth has to prevail. No system could be foolproof unless we cooperate. And I believe this incorporation of the news provision, like for example the videography and all that, has been done with good intention. And if we cooperate, only then this good intention will fructify, and we will enjoy the fruits of this good intention, and we will benefit, all of us as such. Then there were occasions where people would enjoy the proceeds of crime. Now, in order to curb this practice, there is Section 107, I would say. This is a new provision which has been added to enable the police, with the permission of the court, to attach and forfeit any property obtained as proceeds of crime. Now, this is not a blanket power given to the police. One allegation or one concern expressed by some section of the society, or some people, I would say, not sections, they would say that police are given tremendous powers. But there are checks and balances. It is not that they are given unbridled powers or unfettered powers and they can do what they want. It is not so. No, they were always subjected to the powers of the court, and that remains as such. So any abuse of powers, be it by any of the authorities, there are checks and balances, and that would continue to be there. Those checks and balances are not taken away as such. Okay. Person cannot easily get away with whatever he wants to do with the new provisions coming about. He cannot say now it has become much more easy for me to, do what I want. It is not so as such. That perhaps is a mistaken impression about this new laws. Then there were hierarchy of courts, or rather hierarchy of courts are there in provisions of CRPC. There were metropolitan areas, metropolitan magistrate, those things, metropolitan areas, metropolitan magistrate, that has been deleted from this new code. And Section 2K8, 16, 17, 19, 355 and 404 of CRPC, they do not find any place in this new law. And this post of judicial magistrate of third class, then you have assistant session judge, those posts have also been done away with. They have been abolished. This has been done to bring about uniformity as such. I've spoken a little bit about Indian Penal Code, the old Indian Penal Code, the new Bharatiya Nyaya Sanhita. I've spoken a little bit about Bharatiya Nagrik Suraksha Sanhita, and I would add some more to that. Now, some more would mean there are these provisions which were dealing with prohibition to carry arms. There was the Section 144A of the CRPC, which conferred power on the district magistrate and the state government to prohibit carrying of arms in possession of mass drill or mass training. Those provisions have been deleted as such. And there are provisions regarding maintenance proceedings also. Some of you might be aware of this Section 145, of this new law, Section 145 of this Bharatiya Nagrik Suraksha Sanhita. In that provisions for maintenance are made. And those can be initiated with this new law coming to being at the place where the dependent father and mother resides. Father or mother, where they reside, they can initiate those proceedings from there itself. So jurisdiction-wise, it has been made convenient. So looking at it from the citizen's point of view, it is really, really helpful provision as such. Okay. Now, of course, some states are ahead in terms of this law as such. Some states are provided for maintenance to grandparents also. have our legislatures missed an opportunity? It may not have been brought to their notice. We were always free to suggest whatever changes we want or object to the changes that were being brought about. And if we have done a proper job, perhaps those changes also would have come about. But there is always scope for further improvement that can happen with the passage of time. But as of today, what has been done is really good, I would say. And only time will tell how far, some provision, if they get challenged, whether they stand the test of constitutional virus or not, that only time will tell. Then there are provisions regarding proclaimed offenders as such. Okay, under this new law, proclaimed offender, he can be declared in all offences which are punishable with imprisonment for 10 years or more, or with life imprisonment or death. This is, in short, something to do with your criminal procedure code. Now, without wasting much time, because I'm conscious of the time that we have at hand. Now, I'm moving on to the third law, which is called, earlier it was called Indian Evidence Act 1872. Now it is called Bharatiya Sakshya Adhiniyam. Bharatiya Sakshya Adhiniyam. This Sakshya Adhiniyam, as my senior colleague has pointed out, it replaces that Indian Evidence Act 1872. Now, applicability of this new law has been extended to court-martial proceedings as well, which are not there earlier. No, court-martial proceedings which are convened under Army Act 1950, Naval Discipline Act, or the Indian Naval Discipline Act 1934, or the Air Force Act 1950. Then this new law, Bharatiya Sakshya Adhiniyam, it primarily broadens the scope of this Evidence Act as such, and it addresses admissibility of digital evidence to keep pace with the advancement of the contemporary world. The world is moving ahead at a very fast pace, and we were required to keep pace with it. This law has done that, which would enable us to keep pace with the advanced technology as such. Now, this very definition of evidence, that has also been expanded, and rightly so, to include statements made through electronic mediums, facilitating electronic deposition for witnesses, offenders, experts, and victims, and thereby it would reduce logistical challenges to a great extent. Then additionally, this electronic and digital records, they are now classified as primary evidence. Earlier there was secondary evidence, now it is primary evidence under this section 57 of Bharatiya Sakshya Adhiniyam as such. And thereby it is underscoring their importance in the legal proceeding. Primary, nothing more needs to be done. You don't have to give notice, you don't have to resort to those kind of procedural thing whereby you have to bring secondary evidence on record as such. Now this colonial era terminology, like vakil, pleader, then you had barrister, all those needed to be done away with, and that has been done with this new law. And it is replaced with simply a word called advocate, thereby modernizing the legal language. That is also good incorporation. And you'll be surprised to know, if at all you're not familiar with the things which are already there in the old law, there were terms and phrases like Parliament of the United Kingdom, Provincial Act, notification by the Crown Representative, London Gazette, any dominion, colony of possession of His Majesty, jury, Lahore, United Kingdom of Great Britain and Ireland, Commonwealth, Her Majesty or by the Privy Council, Her Majesty's Government, copies or extracts contained in the London Gazette, or purporting to be printed by the Queen's printer, possession by the British Crown, Court of Justice in England, Her Majesty's dominions. All these are now a thing of the past. This colonial terminology, archaic terminology, all this has been done away with, and it needed to be done away with. There would have been they were little an eyesore or an obstacle, as in when you read the old laws. Now, rightly, they are done away with. Okay. Also, this word coercion that has been added as one of the elements causing confession to become irrelevant under section 22 of this new law as such. Now, after having spoken a little bit about this Evidence Act, now I will move on a little more and expose you a little more about something more on this. Yeah, we can if you all want to. Okay.
Here we take a small break. Meantime, you can be ready for your question and answer. You can post it on the comment box. In the end, we'll take the Q&A and let the flow keep on going.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. You know, knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with Citizens Justice Forum. And don't miss out on their fantastic content. Subscribe to their channel now and let's build a community of informed and empowered citizens together. Knowledge is power, after all. Stay connected, stay informed. And
Yeah. Okay. I'll carry on informing you all, or rather educating you all, or apprising you all of few more things here and there, so that it becomes easy for you to appreciate what it is. Okay, what this new law entails, as said. Now, as I said, this act, this new laws, they are intended to overhaul this Indian legal system, and the whole intention, the whole purpose is to establish a justice system which is based on Indian thinking. Believe me, there's a difference between Indian thinking and non-Indian thinking, I would put it that way. No? So, as I have been pointing out all along, in whatever I've said so far, this criminal laws, old ones had their own problems. Now this new criminal law will set people free, looking at it from a citizen point of view, from their colonial mindset, no? Or its symbols, and decolonize our minds as such. No? It is meant to do that, the whole purpose is that. And this new laws tend to focus on justice rather than punishment. See the shift, see the paradigm shift that is happening, focusing on justice rather than on punishment. No? I say this because one of the things I can point out at this juncture itself, the community service. It is not that we are trying to punish that person, we are trying to reform that person. So there's a shift from punishing a person to bringing about justice. Also, there is that, using Indian terminology, there is that sabke saath samman vyavhar. There is equal treatment of all the people across, all the stakeholders across, samman vyavhar. You're not treating somebody unequal, like we are bringing about gender neutrality and all those things. So, samman vyavhar. Whether we are falling short somewhere with regard to fulfilling this objective, maybe so, but as we go along, many more changes can be brought about as a need arises and whenever it can happen. Then there is this whole thing reveals the real spirit of the original Indian Code of Justice. It was also said by some colleagues of mine that earlier there was that colonial mindset of punishing people. Now the whole purpose is to bring about justice. It's not to punish people for the wrongs that they do, but to bring about justice. That is the whole endeavor. Also, these laws in a way guarantee freedom, personal freedom of expression. Also, the value of human rights is at the core of all these laws. And it ensures a victim-centric justice as such. Then the soul of this new law is nyaya, justice should be done, samanta or nishpakshata, without taking any sides, without any prejudice, samanta, similar, equal treatment kind of, that is at the core of it. And there is the spirit of Indian ethos, which makes a paradigm shift towards more citizen-centric approach. The Indian ethos, the Indian taste has been brought into it, not just the taste. It affects us one way or the other, depending on what ideology we are following, what is our mindset, whether it's an Indian mindset or some other mindset. So this, I've already mentioned this. Let's say, for example, this section 173I of this new law. no new criminal law as such, no criminal procedure code. That gives citizen to file an FIR, right to file an FIR through oral or by electronic communication. No? So you can initiate that FIR orally or by electronic communication, irrespective of the area where the offence is committed. Citizen can file a FIR. I will be elaborating more on this as I go along. If somebody needs to know right away, I may lodge an FIR by sending a communication electronically, and within 3 days I've got to go and sign that FIR. Now there could be question raised as to what the police officer does within those 3 days. Those questions I will address. Some questions I know there could be most frequently asked questions, therefore I will myself address them, so that somebody who rather doesn't want to ask such a question, for the fear that it may be a too silly a question, I will be already addressing that question. Then if you see further, citizen is also entitled to get a free copy of FIR. Earlier it was the experience of some people, getting a copy of the FIR also was a much, not so easy, or it was, they would have some problems to face. No? And that copy would come without any delay. Those provisions are there in 173(2) subsection 1. Now the police also are mandated to inform the victim on the progress of the investigation within 90 days under section 193(3) of this new law. No, so look at it, that was never there. No, victim was a victim and he remained a victim throughout. And all the time, the perception that he was getting, or the what he would always feel perhaps, is that look at the accused, he's getting away with everything, and here I am suffering all the more. Once I suffered because I was injustice was done to me by the accused, and by going to the court of law I'm suffering all the more because I don't even know what is really happening and where is the investigation heading to, when it will get over and all that. So he's got a right to be informed, no, about the progress of the investigation within 90 days. Then you have section 184 of this new law. It provides for medical examination of the victim that has to be conducted with her consent as such within 24 hours of receiving information about the commission of the offence. We know very well that any investigation, any examination, if it is conducted belatedly, very late, then it loses its very purpose. And for all you know, the result may be not helpful to the prosecution at all, and the accused may get away with the worst of offences. And we know on technical grounds, many accused have got away. So such provisions will bring about, real justice to the citizens as such. And medical report also would have to be forwarded within 7 days under 184 of this new law. So a time frame. As I go along, I'll be saying a number of things about time frames, timelines, time limits being in place. That is really a new incorporation coming about through this new law. Just as you had this Arbitration Act amended and many timelines are in place, and it has become really helpful. Earlier we would say arbitration is really inexpensive, and it is a quick procedure compared to the regular court proceeding, which was not really so. But timelines being in place, that is really becoming a real alternate dispute resolution. So also with timelines coming in place in this new law, it would be really helpful to everyone. Justice would be done, I would say. No? If you go further, the citizens are also empowered to engage their own legal representation to assist the prosecution under section 18(8) of this new law, new criminal procedure code, Bharatiya Nagrik Suraksha Sanhita. Earlier also, were they allowed to represent? They were allowed to represent. But one had to really, say, I am the victim's advocate, this, that. And he may not be, as a matter of right, though there were case laws in support of that. But today he can say, okay, this section, the law itself, the statute itself gives me this right, to say what I have to on behalf of the victim. Therefore, victim could be represented to assist the prosecution. Look at the terminology. Prosecution is doing its job because that particular offence would be grave, cognizable, and therefore he needs to do a good job of it. But over and above that, he gets the assistance of a victim's advocate also in support of what he's doing. And that would be really helpful to bring justice. And with all such provision, the criminal justice system is made all the more transparent, accountable, accessible. These are not just words or just adjectives, but they are really incorporated in a big way in this new laws as such. You will find in section 230 of this new law, Bharatiya Nagrik Suraksha Sanhita, that the supply of documents to the citizen has been introduced. And that is also really helpful. Citizen is kept in the loop because he is the one who needs to know. Then you have, as I said, victim has a right to free medical treatment and victim compensation under section 396. Of course, somewhat provisions regarding compensation, they were always there in 357 and the subsequent sections. But then this has been categorically brought about in this new law as such. So free medical treatment and victim compensation, it is kind of empowering or rather giving a right, entitlement to the victim. No? Also, you have provision for, as I said, witness protection scheme that will embolden the witness to come forward. Today, as I said earlier, which I commented, victim is a bit hesitant, witness is a bit hesitant to come forward for various reasons. And to a great extent, those fears would go away and he would perhaps want to volunteer and come forward and help the justice delivery system. No? When I was giving a talk to some cops and some law students about a week or so ago, I found that one of the cops came up and requested the student fraternity and the lawyers who were present and the others, some NGOs were present. I found them requesting all these people to help the police. No, especially by coming forward as witnesses. It was really a request from them to do so because they found that perhaps they could be handicapped if the citizens don't cooperate to bring justice to citizens themselves. So there was a request which went from them. Now this new laws, they have thereby brought about Nyaya-centric approach to criminal justice. Nyaya is justice-centric approach. The whole approach has changed as such. No? Like if you go to higher studies, you'll find that the whole shift is happening from punishment to, kind of reformation and all that. No? So that shift is really happening in a big way. It's introduced in this new laws and it will be seen more and more as time passes by. And also you will see the last section perhaps of section, this new law, Bharatiya Nagrik Suraksha Sanhita, section 530. It allows for investigation, inquiry and trial proceedings also to be held electronically. My God, what a world of difference it would make. Imagine the hassle that one has to take or the trouble that one has to take to get to the place where he has to depose and so many other things it would entail. No? All that trouble could be saved with this introduction of this electronic investigation, inquiry and trial as such. Going further, this, if you talk about this key changes, as I said, in Indian Penal Code, the number of sections are reduced 511 to 358. They have added 20 new offences. Compulsorily, some minimum punishment is laid down there. So once the guilt is proved beyond reasonable doubt, that is the requirement of criminal law. Whenever a guilt has to be established, it has to be established beyond any shadow of doubt, beyond reasonable doubt. Unlike your civil proceedings where there is that terminology or phrase called preponderance of probability. Even if it was probable, that could be acceptable in civil law, but not in criminal law. Either you're guilty or you're not. So that is how the criminal law goes. There are two new laws which have come about, which we have pointed out. One is Bharatiya Nyaya Sanhita 2023. The other is Bharatiya Nagrik Suraksha Sanhita 2023. These are criminal laws. The third one is law pertaining to evidence. That is Bharatiya Sakshya Adhiniyam. Evidence law is applicable to both civil as well as criminal law. It won't be right on a part to say 3 new criminal laws are come. No. 2 new criminal laws are come and 1 evidence law. There are changes made in that evidence law. So 2 new criminal laws and 1 evidence law. So imposing minimum punishments for certain offences, thereby it makes it difficult for certain accused to get away. Minimum that mandatory punishment he would have to undergo once the offence is established, when the wrong that he has committed against the society is established as such. And we'll also find as we go along, I will mention those offences for which community service is prescribed. When you come to that, you'll find that there is no clear mention of what duration that community service should be. Now, whether it should be 6 months, 1 year, 2 years, nothing of the sort is mentioned. It seems that the legislators have left it to the discretion of the judge, the magistrate, to impose the duration of that punishment of community service. First of all, it won't be right for me to say that it's a punishment. It's a service towards the civilized society and it should be looked at it in that manner. It's to reform a person as such. Therefore, we will not use the wrong terminology and say punishment. We would rather say though it is under the punishment category, but it was basic intention is to reform a person. And then the quantum of certain punishment has also been enhanced. No, earlier it was this much, now it is enhanced to double the fine amount, and punishment also is increased. Somewhere death is brought about, somewhere till the person, till he lives, as long as he lives. That kind of, exactly not that terminology, but that is what the legislators mean. I will clarify that thing also, what is imprisonment for life and what is that thing where the punishment would be till as long as he is alive. I'll clarify that as I go along. Okay, when I come to specifics. Then another key feature could be it has consolidated crime against women and children. That was necessitated because this is a category which needs special treatment, and if all laws pertaining to them they are brought under one roof, chapter 5 as I said, it would be really helpful. As we go along, we tend to memorize also and we'll know where to look for offences against such category of people. Then when it comes to false promises and all that, as I pointed out earlier, stricter punishment is imposed. Section 69 will tell us so. Then death penalty for gang rape is also introduced, death penalty. Okay, section 70. And I said mercy petition and all that, they are to be disposed of timely. That also has come about. Then as we go further, you'll see that in CRPC there were 484 sections earlier. Now those number of sections are increased to 531. Don't get a little put off because the number of sections are increased, or even when they are reduced also. That does not really matter. What matters is whether the changes are good or bad, whether they are helpful to the citizens or not, looking at it from the citizen perspective. I would rather say it would perhaps not be right for anyone to look at something only from a certain perspective. You've got to look at something, holistically. From the citizen point of view, from the accused point of view, from the societal point of view, from the judiciary point of view, from the judge's point of view, and all stakeholders' point of view, witnesses as well. So it should be that way, I feel. Then, we would also see that in this new criminal law, you would see they have replaced some 177 sections. They have added 9 new sections. They have repealed 14 sections. Why am I throwing this number? Because some would say that there are only cosmetic changes made. Kali naam badal diya or kuch kiya nahi. That is not true, I feel. I was reeling under a similar impression much before I could delve deep into some of these laws and try to understand them better. The presumption in law is that whatever the legislature made, that is good. And we have to find the purpose behind it and the intention of the legislature behind it. Only when we have that presumption in mind, we would go about in a right way and we would be able to appreciate what has been done. Would there be some problem with the new laws which have come about? There may be, but that for the judiciary to interpret the laws and the laws when they are tested as such, if at all by anyone. Now, we have seen that there is an enhancement of the use of technology in investigation. Also, there are increases in fine. Also, FIR processes, victim protection, that has been streamlined. We have spoken about zero FIR, e-FIR. This is e-generation that we are talking about. No? So there is e-FIR also. There is that 176, the law permits audio, video recording, audio, video, not just video, audio as well, of victim statement. It makes a huge difference, because many times, if you are a practicing lawyer, you would know the person in the box is saying one thing, then he said, no, I have not said this. Then he would say, I don't know why the police have not covered what I've said. All these disparities and discrepancies and inconsistencies, or going back on one statement or sticking to one statement and not finding that statement in the thing that is recorded. All those, to a great extent, all this would be addressed with the coming of this, introduction of this audio, video recording of victim statement and so on. I had one case where the lady had lodged an FIR and thereafter she had given a statement. Thereafter she gave yet another statement and thereafter yet another statement. And then finally she started saying the first statement which I gave was incorrect, the second one was correct, then she said the third one was correct, and there was a whole lot of confusion. Her argument was, or justification was, I don't know Marathi very properly, and therefore what I said in the first statement wasn't even wasn't even told to me properly, and I didn't really understand what I had signed, and all such things she was saying. perhaps all these things would be put to rest to a great extent with this incorporation of this latest technological advancement in the provisions of law itself. As far as evidence law is concerned, we'll see that there is increase of a couple of sections. Earlier there were 167 sections, now there are 170 sections. And there are changes only in 24 sections out of these many sections, and 2 new sections are added, and there are some 6 sections which are repealed as such. Now these key features are this, it recognizes electronic digital records as primary evidence, which I've earlier mentioned. It provides framework for digital evidence authenticity as such, no? And it gives an expanded definition of documents, the most important definition. It expands the definition. And then there is a parity in admissibility of digital records as other documents. Sometimes there would be a reservation or hesitation on the part of the court to say whether certain copies should be given to the other side, to the accused side or whatever. But now when parity is brought about between your regular what we call documents and the digital records as such, that will make a huge difference when it comes to giving copies as such. Then as far as admissibility of electronic record is concerned, they are acceptable in the court of law. No, they are acceptable. No, there were provisions in law whereby they see whether something is acceptable or not. With these changes brought about, digital evidence acceptable. There would always be this question in the mind of the citizen when they would approach any lawyer for their taking up their cases. They would say, WhatsApp if so-and-so fellow has said something to me, or he used my WhatsApp and he sent message to himself and he has misused my mobile. Whether that would be tenable in law, that evidence can, whether it can be acceptable in the court of law or not. All those queries would be raised by them. And today there are clear-cut answers to all those queries, and I believe that there shouldn't be any apprehension on those counts as such. I still remember one of my clients, he had gone to the extent of, even before this law could come about, many years earlier, he had pulled out something which was put out on the Facebook by his wife, and he said, this is what she has put out, and she's saying that her ornaments are with me, but he's saying that evidence is there in the Facebook. His query was whether that would be acceptable by the court of law. Yes, it would be, but there's a time for accepting that evidence that can be done only during trial. Based on that, you cannot expect the court to say, okay, there is this evidence on Facebook, therefore I discharge you at this stage only, I quash the whole FIR and I let you free. No, I short circuit the whole procedure. That may not happen, no, but only time will tell whether such an argument would be made or not. Then you have this women and children, which I've already said. There are this new criminal laws which have introduced, or rather it includes 37 sections addressing crime against women and children. 37 sections. The number doesn't really matter. What matters is whether justice would be done to them. And to a great extent you would see, or rather these provisions are meant to do justice to them. Then you have offences against women and child. They have been made gender neutral, as I said, in terms of both the victim and the perpetrator as well. No? Yeah. Then gang rape with a girl under 18 years of age is made punishable with life imprisonment or death. Looked at it very seriously. Therefore, this section 70 of Indian Penal Code, the new law called Bharatiya Nyaya Sanhita, that this section has been brought upon. Then, as I said, the medical practitioner, they are mandated to send medical reports of a victim of rape to the investigating officer within 7 days. The timelines are very important. No? We always had that problem of the reports not coming on time and the courts being handicapped to that extent, not knowing what the report would really reveal, whether it's person is wrongly framed, whether what is claiming innocent, whether he is rightly claiming or not. And courts will be called upon to take a decision based on certain imagination or other certain documents which are there before them and what the parties are telling the court. No? Court would really have to discern and see and make sure that justice is done. But today it would become a little more easy if these reports are there before the honorable courts. Then as you go further, we have seen that there is comprehensive digitalization at all stages of criminal justice. This infusion of technology in this delivery of justice system, that would help tremendously. You will see as you go along how much it is helping this delivery of justice. No, I'm telling you, everybody will be like awed, and they would say, perhaps with this new offences, new as in any new offences taking place post 1st July, they would be dealt with in a different way, and the offences will be tried timely and the matters will be disposed of within a short span of time. All that would be a reality as such. No? Earlier it was only a pipe dream as such, but now we are seeing that it is going to be a reality as such. Then you have this definition of document, I said. It includes server logs, it includes locational evidence, it includes digital voice messages. All this is important, no? Any apprehension or discount, whether digital voice messages. Is there any scope for tampering with any such messages? See, pervert people or those who want to manipulate something, they will always try their best and they may succeed also to some extent. But you cannot fool the court all the time and so yeah, I'm so sorry for that interruption. Now, as we go along, you will see the scope of the secondary evidence. It has broadened under this law, and it has incorporated oral admissions, written admission, evidence of skilled persons who have examined document. All that you will find in that Indian Evidence Act, the new law called Bharatiya Sakshi Adhiniyam in section 58 as such. And you'll also find that there are procedures introduced for videography of search and seizure. No? As I said earlier, there was no way of knowing whether that search or seizure is genuine, because all the time allegation will be made against the police authorities saying that this was not so, this is manipulated, the whole thing is concocted and all that. I believe that to a great extent all those allegations would not find their place because of the introduction of this new laws as such. That you will find in section 105. You know? As we will see in various provision or particular provision, that victim is also considered as a stakeholder in this criminal proceedings as such. No? Thereby you are providing participatory rights to the victim. Participatory. He is participating in the justice system. He is the one whose rights are at stake, and therefore allowing him to participate through his advocate versus prosecution, that is a big change. I know I am repeating myself, but I am trying to elaborate more and more as I go along, as keeping the time factor in mind. No? We have already said that victim has the right to be heard, and that's a sea change, I would say. No? Then the victim is entitled to FIR copy, he possesses the right to be informed about the progress of the investigation within 90 days. Then witness protection scheme we have spoken about. We have spoken about rape victim. That has to be recorded by a lady judicial magistrate. No? If for some reason lady judicial magistrate is not available, then it could be done by male judicial magistrate, but it would have to be done in the presence of a woman as such. No? So she is like little at ease, not little, much at ease. No? I remember once I had expressed myself saying that it would be, my client's contention is that she being a lady, her feelings, her emotions, what she has to convey to the court, to the advocate, to me, that would be much more understood had it been a lady judge. And I did express this also across. But just like a doctor is a doctor, you can operate on a lady patient also and a gent patient also. I believe judges, in my understanding and my experience, judges have always been non-discriminatory when it comes to either gender coming before them. And they don't look at a person as a lady or a gent in as much as when it comes to doing justice. They do deliver justice irrespective of the sex. Then there are changes in that Terrorist Act also. It covers, as I said, something that poses a threat to India's unity, how important it is, no? India's unity, integrity, sovereignty, security, economic security, or somebody who's trying to spread terror among any group, all that gets covered in this new law. Also, there are changes made to sedition law 124A, as I said. This is eliminated, done away with, and this new law penalizes acts which are endangering unity and integrity of India. Raj Drohi, the people whom we will call Raj Drohi as such. You are living in this country and you're talking against the country, or you're doing acts which are against the country, that will not be tolerated. That message is loud and clear to this new provisions. And there is this introduction of this Desh Drohi as such. No? Desh, you are against the country as such. Then mob lynching also, I have commented in the passing, it is carrying a maximum penalty of death. It is not viewed lightly, because this is something serious. You cannot get together and do away with somebody's life, put him to death or make him rest of his life put him in a vegetative state. You cannot do that to a person. No? Organized crime also is very clearly defined now in section 111 as such, that we will see more of it as we go along. In 45 sections of this Bharatiya Nagrik Suraksha Sanhita 2023, in nearly 45 sections, timelines have been introduced. I'm giving you a number so that you will want to appreciate the changes this time. No? And charges, what is it that is against you? That accused needs to be told. Those charges would have to be framed within 60 days from the commencement of the first hearing of charge, on charge. So that is there in section 251 of this new law. Then prosecution against declared offenders in their absence, that would also have to be initiated after completion of 90 days from the date of framing of the charge as such. 90 days time frame. You cannot just leave it open-ended. Then sanctions for prosecution, supply of documents, committal proceeding, filing of discharge petition, framing of charges, pronouncement of judgment, filing of mercy petition, all that has been mandated to be completed within given timelines. All that is there in section 251 and 258 as such. And then no more than 2 adjournments are allowed to be given in criminal proceeding. You'll find that in 346 of this new law as such. Civil law, there was this section, order 17, whereby the number of adjournments was 3. But depending on the facts and the requirement or the circumstances, there would be more than 3 also. But the legislators in their wisdom have tried to curtail this number of adjournments. It shouldn't be just Tariq pe Tariq and the matter goes on, and the victim and the concerned people are just waiting for justice to be delivered to them. So there are time frames brought about through this provision as such. Then the use of technology, as I said, has been brought about when it comes to issuance and service of summons and deposition of evidence before the court. The technology is being used in a big way, and all that is there in the last section of that new criminal law as such. Now, there is also this provision about magistrate being allowed to conduct summary trials in cases that involve imprisonment up to 3 years. So something that need not be elaborate procedure, and therefore there is a shorter procedure prescribed under the law called summary trials, and that procedure is available for offences which are up to 3 years. Thereby there would be speedy delivery of justice as such. And timely justice, charges, as I said, would be framed within 60 days of the first hearing. And conclusion of the trial in the criminal court, that pronouncement of judgment will have to take not more than 45 days as such. There are sections to that effect, 251 and 258. So some changes brought about there as well. Not just the trial has to be concluded, but judgment also has to be delivered in time as such. Then there is a provision regarding director of prosecution. State would have to have a directorate of prosecution, under which every district will have a district directorate prosecution, which will monitor cases which are under trial to expedite the proceedings and to give opinion of filing of appeals. Appeal would not be filed where it is not required to be filed. Only when a challenge is, perhaps would be maintainable or which could sustain, only that kind of challenge would be preferred in the form of an appeal. That care would have to be taken. You just don't challenge anything and everything for the heck of it. And then electronic mode for inquiries and trial, that is also incorporated. All inquiries, trials would also be conducted in electronic mode. Just imagine the ramification of this, the implication of what we are saying. Trials and inquiries, those can be conducted in an electronic mode, the last section. Then it provides for release of under trials also. First time offenders, they would be released if their under trial detention reaches 1/3 of this section. Imagine if this was to be incorporated as in brought about, enforced immediately. All those who are languishing in jail, they would, if they have under trials, they are just there waiting for their trial to happen. If this was there, 1/3 of the sentence, if they have already served, they would all have to be released, and thereby reducing the crowding of various jails. Okay, I had the fortune to visit various jails, right up to the biggest jail in India, Tihar jail, and also Yerwada jail, and also Arthur Road jail, and so many other jails. Thanks to the colleges that I was teaching, and I was fortunate to take the law students to various jails. And real learning happens when you actually see the accused serving their sentence or the under trials being lodged in various jails and what kind of treatment they get there. Half the things that we say are really imaginary. It only takes a person who's visited there to tell you what the reality is. And it's not what we think it is. It is far better. It is really, I wouldn't say it's heaven there, but then the food and all that is standard. For everything there's a manual. And the cops make sure that they follow the manual. There could be some aberration here and there, some shortcomings here and there, but that is there in every system as such. So, yeah. Then after release of under trials, I have already said about mandatory videography. Then when it comes to arresting, the arrest would have to be done not without the prior permission of the officer below the rank of Deputy SP in case of offence which is punishable for imprisonment for less than 3 years, and such person is, if he is infirm or 60 years of age, so you need the permission of not less than a person of Deputy Superintendent of Police. They have raised it to that level. Today, if you see, even the cops are graduate. So one would wonder, why not empower them? But legislatures in their wisdom have thought that these people who are better qualified and in a better position to really take a call whether somebody should be punished or not, that responsibility is cast upon them. Rather, they're saying police are given much power. Here are places where they have looked at it from citizen-centric, citizen point of view, and these provisions are really something which one can appreciate as such. Then you have 20 sections which have been introduced to enhance police accountability in arrest, search, seizure, and investigation. You want to look for the details to see where this accountability is there in the provisions themselves. You cannot take a cursory look and say the whole of the act is rubbish or it's bad or it's good. You can come to neither conclusion unless you really apply yourself and really go to certain provision and look at it from the practical point of view. Then there is something in law called non-cognizable, which are not serious kind of offences, for which the police, if a non-cognizable offence is taken note of in a police station, then the police cannot arrest you. Then the daily diary report of all such cases, they are required to be forwarded to the magistrate fortnightly. Okay, that is there in section 174 of non-cognizable cases. Mind you, if you are a citizen, some of you are on the watching this program, as a citizen, if it's a serious offence, serious to a layman. Don't go by what the law says. Something not necessarily which is punishable for 3 years or more. Sometimes it could be less than 3 years, but it should be serious. So if it is so, you got to tell the cop, you got to tell the police authorities to register a first information report, and then the investigation machinery would be set in motion. But if it's not serious, then he would be within his right to record it as only a non-cognizable offence. Something where he would not be able to arrest the person as such, he would not be able to investigate unless the magistrate gives him permission to do so as such. I don't know whether we need a break at the juncture, but
we'll take a short break and then we'll join again.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. Knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with Citizens Justice Forum. And don't miss out on their fantastic content. Subscribe to their channel now and let's build a community of informed and empowered citizens together. Knowledge is power, after all. Stay connected, stay informed, and subscribe to Citizens Justice Forum. See you there. Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. You know, knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in.
So here we are back again. There are many queries which we are going to answer, like a witness, if he wants to give his witness evidence, he can do online also. So there may be, chances of him getting tempered or him getting tutored behind the camera with someone. So that also one of the questions has been raised, and we'll go forward with the flow. And there are many other questions which have come that we have already passed to Advocate Prosper D'Souza. He is going to answer that. And still, if you have any questions, you can post on the comment box and we'll address that. Yeah.
Yeah. Now, we'll go a little more into the depth of certain provisions, not exactly into the great details. If you wish to do that, we can do that also. But it'll be at the cost of some other provision, and we'll be only looking at some specific provision if we try to do that. So as I go along, I will address some of your concerns to the extent possible, all of them. Okay. Now, there is a distinction between substantive law and procedural law. No? Substantive law, if the law says if you do certain offense, you'll be punished for 3 years. If that is the law in that particular date, then you will be punished for 3 years only and not more. No, that is substantive law. But the procedural law can be backdated also. No, that is the beauty of procedural law, or it is possible to do that. Now, as far as punishment is concerned, as I said, whatever punishment was there on that particular date as per a particular law, that punishment would have to be meted out and not more as such. No? Now, let me come to a little more specific. As I said, I wish to go to this Evidence Act as such, if you allow me to, because I feel that that is not looked at a little more in detail as such. That would help us look at some queries also. No? If you see the definition, electronic and digital records and all that, you'll see section 2(1)(d), it gives a definition of the word document. No? And that definition is compatible with this modern technology as such, or modern digital era as such. We need to actually look at the definition. Document, it says, means any matter expressed. Document, if I have a book in hand, that is not a document. Document is a matter expressed as such. No? Or described or otherwise recorded upon any substance by means of letters, figures. So take an example of a blackboard or a whiteboard. What you write on that blackboard or whiteboard, that written thing is what you're expressing. That would be a document. That figure, that mark would be a document as such. It could be or written by any other means, or more than one of those means, which is intended to be used, or which may be used for the purpose of recording that matter. And towards the end of the definition, they have said it includes electronic and digital records. So rightly so, they have made a change to the definition of document, so that your electronic or digital records are considered as document by the law, by virtue of definition itself. Then if you look at another definition, evidence. Evidence also you'll find these things incorporated there. So I don't wish to take you through each and every definition. I just realized that would take quite some time. As far as video recording on mobile phone is also permitted, that would also qualify as a documentary evidence, as it is otherwise recorded upon any substance or by any other means. So if it is video recording on a mobile phone, that would also pass as a documentary evidence as such. Then be it laptop, be it smartphone, messages, websites, local evidence, voicemail messages, which are stored in digital devices, they are also documented. One of the concerns expressed, why I raise this up again, is one of the concerns expresses, are these evidences stored in this manner? Is there enough storage space? Is there enough infrastructure? I would say it doesn't take much to provide for infrastructure. And I believe there is infrastructure in place, no? And doesn't, maybe costing a little bit, but I don't think that would be a big problem as such. As far as tampering with this evidence is concerned, whatever tampering is happening, that would leave some traces of tampering. Let me clarify what I'm saying. Many of the youngsters, they are under the impression perhaps that whenever they post something in some group or somewhere, or send it to somebody known to them or unknown to them, and thereafter if they delete it, they perhaps may be under the impression, reeling under the impression that once they have deleted, it's gone. Now it is not traceable. It is not so. Whatever you do on this social media, it leaves footprints. It leaves prints behind it. It leaves carbon prints. As in some evidence will be left behind on the server or on the system somewhere or the other, and that would be traceable as such. Traceable, and that could be brought on record by the prosecuting authorities. Whether they are in a position to do that, from my past experience, I would say yes, very much. I had one case where a person, somebody had gone missing, and the police authorities were so sharp, and we were following up with them, and we were assisting them, we were cooperating with them. I'm using this word because no system will work unless we cooperate. As Dr. Babasaheb Ambedkar was asked, it seems, whether this constitution is good, whether it is working, whether it will work or not. He said nothing can work unless people cooperate and make it happen. So also this changes. If we make it happen, we cooperate with the authorities which are there placed. Only then it is possible. We have to collaborate and we have to make it work. Now, that lost person, as I was saying, the moment that missing person mobile was on, for a few seconds, the cop came to know her location, and right enough, we reached that location and we found that missing person there. So such instances were there not only now, they were there earlier also. Cops, there are trained cops, there are police station, BKC, you have that police station where you have that cyber crimes and all that recorded. We have at other places also in town. So they are training more and more people, with regard to crimes committed digitally and on social media. And I find that they are coping up, they are catching up with this advanced technology. They may not be as expert as the perverts or the criminals or those who are tampering with this record, but I believe they are in a position to track them and bring them to book. That is how I look at it. Electronic digital records, I've said what I could, or rather what is needed to be known by all. I proceed a little further. Now, there is one provision towards the end of the definition of this Indian Evidence Act, the new name being Bharatiya Sakshya Adhiniyam. And that provision says words and expression used here and not defined here but defined in the IT Act 2000, the Bharatiya Nagrik Suraksha Sanhita, that is a new CRPC, and the Bharatiya Nyaya Sanhita, that is a new IPC, shall have the same meanings as assigned to them in the said Act and Sanhitas. Meaning thereby, if I have to simplify what I have just said, it simply tells you that whatever definitions are not given in this Indian Evidence Act, those definitions you can look them up, any shortfall of definition here in this small inbuilt dictionary in this Indian Evidence Act or this new this Sakshya Sanhita. You can look for the definition in the Indian Information Technology Act 2000 or in this two new other criminal laws. You can look for the definition there. That wasn't there earlier as such, which I had not said before. Therefore, I wanted to bring this to the notice. Now, as far as other provisions are concerned, you have, as I said, this word called vakil and pleaders and all that done away with. It is replaced with advocate. And then there were some typographical errors earlier in that section 8 of this Evidence Act, Old Evidence Act, no, the word proved was there, the word that was corrected by making it provided. Certain section, there were some typo errors that also is set right with the coming of this new law. And in one of the illustration in section 8, no, which was about motive, preparation, and previous or subsequent conduct, there was this problem of this word, of the word man was used. Now it is replaced with the word person, no, to make it gender neutral. I recall our Honorable Chief Justice of India, after being elevated as Chief Justice, he had come back to Bombay High Court, and he was giving a talk on, I believe, on Constitution. And that time he happened to make a statement saying that to the extent possible, laws should be gender neutral as such. And we see that already being implemented through this new laws as such. This is not to please anybody as such, but that was the requirement of the time, gender neutral law. And that has been done. Okay. Also, in that word, in one of the illustrations, J, there was that word ravaged being used. Now that word is replaced by raped as such, to give a proper sense of what is meant. No, the word raped is used. Then as we go along, you will see that I'm not touching upon each and every aspect. I will just tell you all what is really needed to be known. Now earlier in that old Evidence Act, this word coercion, that was not there, that is now inserted in section 22. Coercion, that was the word used in Indian Contract Act, force somebody, that word is also incorporated, no? And in the right place, which would be really helpful. Then you have, I'm just trying to just tell you all about certain important provisions as such. Now there was this issue of somebody being absconding trial. Let's say there are 4 accused, one of them goes absconding. What happens to that? Now with the coming of this new law, this new explanation has been added to section 24. It says that the trial of more person than one, if it is held in the absence of the accused who has absconded or who fails to comply with any proclamation is to make known to that person that you are required to face the trial, issued under section 84 of that new criminal procedure code, that shall be deemed to be a joint trial. So even in the absence of that absconding accused, this trial would be deemed to be as a joint trial, thereby expediting the conduct of that trial as such. Then electronic or digital evidence, as I said, is made admissible under certain provision. Then I'm jumping to other relevant provision. Now this section 45 of that old Act, Evidence Act, there are some changes made there. Section 39 is incorporated, which talks about, provides that opinions of experts in a field other than a foreign law or science or art, they are also relevant facts. The court has to form to an opinion upon a point in that field. So, experts' opinion in the field other than foreign law or of science, or they are also relevant facts. That change is also brought about. Mind you, all the small changes incorporated at various places. Those are done keeping in mind the various case laws, landmark case laws, which have taken place over a period of time, or keeping in mind the advanced technologies or the need of the hour. Therefore, every change will be helpful in one way or the other. There's no time to take you through all of the changes, but then that is how it is. Now you have section 52, which requires the court to take judicial notice of all laws in force in the territory of India, including laws having extraterritorial operation. Extra as in beyond the territory of India. Judicial notice as in then you don't have to prove those things. Court is themselves taking cognizance of those things. So that has been incorporated. Also, judicial notice will be taken of international treaty, agreement or convention with country or countries by India, or decision made by India at the international association, other bodies. That also court will take judicial notice. Then this new law omits reference to all public acts passed or hereafter to be passed by Parliament of the United Kingdom. Why would we keep those provisions? And all local and personal acts directed by Parliament of the United Kingdom. No? Courts in India will not be required to take judicial notice of acts passed by Parliament of UK. Not anymore because of this coming in this new law. Since India has ceased to be a colony of UK since 1946. So this also was required to be thrown away, lock, stock and barrel, and it is done so. Now this section 52 of this new law, it omits reference to the course of proceeding of Parliament of the UK also. And no judicial notice will be required to be taken of course of proceedings in UK Parliament. So also 52 omits accession and the signed manual of the sovereign for the timing of the UK, of Great Britain and Ireland. Why would we keep all that? That also has gone as said. No? Now, reference to territories under the dominance of Government of India, that has been replaced by Territory of India. Under the dominion is gone. It's just Territory of India. It's really appreciable. Indianization, or indigenous things, no, kind of we feel at home, and we really are proud of the changes. Then reference to articles of war for Indian Army, Navy, or Air Force, they are omitted as. Then you have now, of course, section 54 it omits reference to electronic record, because those changes are already brought about in the definition of the word document. Electronic record, digital, and all that stuff is already there in the definition. Therefore, obviating the need for that change to be there in section 54, that has been done. Then you have new explanation which are incorporated in section 62. No? Earlier section 62, now it is section 57. The new explanation clarifies that where an electronic or digital record is created or stored, and such storage occurs simultaneously or sequentially in multiple files, each such file is the primary evidence. So if you are storing something in one file and yet in another file and in another file, all of them are primary evidence. It is not that one becomes primary evidence and the other becomes secondary. One of the queries which were raised with my colleagues during while we took a short break to switch on to a little more, or going a little more in depth, was that some of the citizens are in the court for years together. It is precisely for this that there are times and in place. Now, other concern expressed was, will the courts abide by those timelines? As I keep on harping, as Dr. Babasaheb Ambedkar said, nothing can work if you don't want it to work. No? We have to make it work. We have to cooperate with the system. It is not always that the accused advocate seeks time or date after date. At times, even the complainant's advocate seeks time for one reason or the other. No? Or sometimes you overburden the court with some petty cases also. No? I'm not saying you shouldn't be doing it. You have a right in a civilized society to approach the court, but there is a process called mediation also. There is something called plea bargaining also. So something which you can take recourse to, which provision already there in the old law also, you should take recourse to those proceedings and thereby reduce the burden of the court. Whether the court continues to be burdened in the manner that it was in the past, I don't think so. If we all cooperate, all stakeholders cooperate in a big way, or rather really wholeheartedly, then I see a great reduction in backlog of cases, and I also see that you would be very quickly getting justice, which is the need of the time, and it was always required as such. Because justice delayed in justice denied, that will not remain just a saying, but today we are trying to address that concern of justice being delayed, and therefore the changes in this new law. Whether you would still have to remain in the consumer court for this long or some other court for that long, I don't think so. I don't think so. With the changes being brought about, you would be getting out of this court as fast as possible with this timeline in place. That is my answer to the question raised. So specifically, if you look at the various sections where timelines are put in place, you would see how it helps you, how it is helpful to you. And you have to cooperate. No, I tell my client success or failure of any litigation also depends on cooperation between the client and you. It was only today itself I got a client phone call from a client. Tomorrow I won't be able to make it. Please take an adjournment. I said, why the hell would I take an adjournment? The court is ready with the matter. I am ready with the matter. Just because you are not able to make it, you are not going to seek adjournment of the matter. Now, if I were to take the client's request into consideration, I would be delaying the whole process of justice. Justice means if you are wrong, you are wrong. If you are right, you are right. No, justice has to be delivered on time. So that is how we will look at it, and that is how we will make the system work as such. Then going a little further, there is some explanation incorporated in section 57. So it says, explanation 4 says, where an electronic or digital record is created or stored, and such storage occurs simultaneously, as I said, or sequentially, each of it is primary evidence, as I said. There is yet another explanation which clarifies that when an electronic or digital record is produced from proper custody, such electronic or digital record is primary evidence unless it is disputed as such. And further explanation will say, video recording is simultaneously stored in electronic form and transmitted or broadcasted or transferred to another. Each of the stored recording is primary evidence. So in law, those who are advocates or those who have some understanding of law would know how this would be really, really helpful in taking their cases forward and getting justice, timely justice. Then again, yet another explanation clarifies that where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. So all what would have perhaps been in the realm of secondary evidence is now would be treated as primary evidence as such. And under section 58 of this new evidence law, you have oral admission, you have written admission, the evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of such document. Such a definition is there in section 58 of this new law. Going further, you'll see that section 16 of new law also provides that electronic or digital record will have the same legal effect, validity, and enforceability as paper record. This needed to be told upfront and needed to be incorporated in a very formal way, because till date perhaps we were not treating electronic evidence or digital records at par with your documentary evidence or paper records. With this formal incorporation in section 61, we would be compelled, or it would be mandatorily binding on us to treat them as such. Then you have section 61 in the new law. It will apply to, it says, Adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record. Or rather, let me simplify this. It says that you cannot say that this is not a digital record, this is not an electronic record which should be admissible in law. So they have brought that to it would have to be made admissible and accepted as such. Then the reference to state of Jammu and Kashmir, that is also omitted, since that legal entity has ceased to exist from 31/10/2019, and what exists now is this Union Territory of Jammu and Kashmir and Union Territory of Ladakh as such. That change was also required to be brought about. That change is also made. Then if you go to section 80 of this Evidence Act, you find that references to those foreign things, London Gazette, Official Gazette, all that is done away with, cutting a long commentary in short, just to make you comfortable with what I'm delivering. Then and you have now here in this new law given in section 80 and section 92 of this new law, which a document is said to be in proper custody. We mentioned that proper custody, if it is in the place in which and looked after by the person with whom such document is required to be kept. So ordinarily, if you are keeping that document in certain place, then that would be a proper custody. And no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render that original probable. So just, it's enough to show that that origin, where that document is coming, that was probable, it was possible in law, that will be considered as proper custody as such. So any controversy on this count would be put to rest as such. Then you have section 81 of that old law talking about evidence in the Evidence Act. And you have corresponding section in section 81, that was 81A in the old law, and new is section 81 of this new law as such. Then you have this new law clarifies that for the purposes of this section, it says in section 96, electronic records are said to be in proper custody if they are in place in which and looked after by the person with whom such document is required to be. So further clarification is also there. We move ahead to look at other things. Now in Evidence Act, there was a section 85 provided that court shall presume that every electronic record purporting to be an agreement containing the electronic signatures, the party was so concluded by fixing the electronic signature of the party. In new law, you have section 85, which has incorporated the word digital signature. That was required to be done because we are in a digital world now, and that change has been brought about by section 85, where it says that court shall presume that every electronic record purporting to be an agreement containing the electronic or digital signature of the party was so concluded by fixing the electronic or digital signature of the party. So there's a presumption in favor of that electronic or digital signature. Of course, all presumption in law, by and large, can be refuted. Other party can say, no, it is not this proper signature, but it would take great effort and proper evidence to do that. So, then you have certain changes made in that section 88 brought about in this new law. Outdated references to magistrate dominant that has been omitted. For words, place not forming part of India, that is to be replaced by place outside India as such. Then for words, any country and not forming part of India, words, any country beyond India are used as such. Then you have some explanation to section 92 in this new law. It says, which refers to custody of documents. Then you have other provisions also. I'm looking at the most important provision that you all need to know. And I've already said reference to lunatic. We are no longer required to use that word lunatic. It has been replaced by person of unsound mind. Okay. In other laws, you find person suffering from physical or mental disability, thereby broadening that definition in such a way that it becomes an open-ended definition to include so many people. If you were to say mental illness, perhaps it could have been problematic. In the bill, there was this term called mental illness used, but now they are saying physical or mental disability, which is a much broader term, incorporating many more cases which would be required to be dealt with in that manner as such. No? Now, there is for those, we are talking about evidence law, and we have already said that evidence law not only deals with criminal procedure as such, as in criminal, something to do with substantive criminal law, it has to do with substantive civil law. Look at this now. This is for landlords and tenants. There is some change made in section 122 of this Bharatiya Sakshya Adhiniyam as such. Adhiniyam as such. What is that? It provides, now listen to this carefully, it provides that no tenant of immovable property or person claiming to such tenant shall, during the continuance of the tenancy or any time thereafter, these three words, any time thereafter, have been incorporated. So listen to further. It says, or any time thereafter, be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. You have to oversimplify this. It means that if you are inducted by some landlord as a tenant on some property, tomorrow you cannot get up and say, he is not my landlord. I know for sure that he has cheated somebody and the real landlord is somebody else. Therefore, I will stop paying rent to him. I will not get out of this property. I will overstay, which is called tenancy at sufferance. He cannot take any such plea. So this subsequent eventuality has also been covered by bringing about a small change in the hitherto section 116 of Evidence Act, now renumbered as section 122. And they are saying, during the continuance of the tenancy or any time thereafter, he cannot deny that the landlord has the title to that property as such. I hope this is clear. If not, I am prepared to clarify again. Going further, I've said that words like barrister, attorney and all that were replaced by advocate. That was also required to be done. Now there was this terminology called legal professional advisor. Those words are also replaced by legal advisor. No professional advisor, legal advisor is good enough. He need not be a professional advisor. Be a chartered accountant, be a company secretary, so many other categories of people. But they would also fit into this legal advisor. Then you have section 138 of this new law, which substitutes that section 133 of the old act. words if is substituted in section 138 for the words merely because, merely because. Then you have section 133 again, where the words not illegal merely because, those words are incorporated. All this will not make sense to you unless I take you to the 138 as such. I don't know whether I would have time for doing that, but even as I'm trying to take you there, since I mentioned it, it is just a two-liner section. It talks about accomplice. Accomplice shall be a competent witness against any accused person, and a conviction is not illegal if it proceeds upon the corroborated testimony of an accomplice as said. This is what has been brought about as said in this new law. Now, before I proceed further, now the number of witnesses required to prove any offense. Law does not prescribe any number of witnesses. Law does not say you have to have 1, 2, 10, 20 witnesses as such. Okay. And in fact, with this advancement of technology and this with the digital era and this e-commerce and e-everything, e-evidence and all of that. Now, more offenses are likely to be proved with the help of this advanced technology. Perhaps there may be a time when you're no longer dependent on a human being who could be lying for n number of reasons. He may have said one thing and he may be resiling or going back on his words or not sticking to what he had said earlier. There was always the doctrine of estoppel in the old act in section 115, 116. That is very much there even now. But all the more reason which is incorporation of the technology advancement in this various laws, he will not be able to go back on his word because he would have to stick to what he has said. Because everything is captured digitally also, and he cannot say something different from what he had said. So this, I would say in my own understanding, that this rule of estoppel, doctrine of estoppel, has even become even more stronger with this incorporation of this technological things in this new law. Barrister word also is one, as I've said. Let's look at certain highlights. Then you have that at the end of it, end of this Evidence Act, you have a certificate given. And there is certain terminology which is given in that certificate, and now it becomes easy, and that certificate has two parts to it. That has made a reference to section 63 of this Evidence Act as said, where a certificate is required to be produced, etc. There were so many case laws arising out of this certificate. Okay. And section 63 talks about admissibility of electronic records. It says, notwithstanding anything contained in this adenium, in this new law, any information contained in an electronic record, which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device, or otherwise stored, recorded, or copied in any electronic form, hereinafter referred to as a computer output, shall be deemed to be also a document. Emphasis on shall be deemed to be also a document if the condition mentioned in the section are satisfied in relation to the information and computer in question. And shall be admissible in any proceedings without further proof or production of the original as evidence of any contents of the original or of any fact stated therein, of which direct evidence would be admissible. It goes on and on. If I have to simplify what I just said, there is the format of a certificate given. If you are giving certificate in that given format, the first part talks about, of that certificate talks about, or the requirement there of the first part of that certificate is to be filled by the party. I will just tell you the main portion of that certificate. It goes like this. The digital device or the digital record source was under the lawful control for regularly creating, storing, or processing information for the purpose of carrying out regular activities, and during this period, you have mentioned that period, the computer or the communication device was working properly and the relevant information was regularly fed into the computer during that ordinary course of business. If the computer digital device at any point of time was not working properly or out of operation, then it has not affected the electronic digital record or its accuracy. The digital device or the source of the digital record is owned or maintained or managed or operated by me. No? And you want to state that the hash values on the electronic digital record is obtained through the following algorithm. No? You would give the algorithm set. Basically what I'm trying to say here is you are making a self-declaration and you're taking the responsibility that no tampering has been done with that digital
Same thing as before.
No? And especially for that particular period. And without any changes have been made therein, that is not affecting the record or the accuracy thereby. So the concern which was voiced by my colleague, how far this would be, not tampered or not prone to be tampered, not vulnerable to be manipulated and all that. That concerns are being addressed to this certificate as such. And the latter part of certificate is to be filled in by an expert, and it says, I so and so residing at so and so, sincerely state and submit that the produced electronic record output of the digital record are obtained from the following device, digital record source. Then you will mention the source, whether it is DVR, whether it is mobile, CD, DVD, server, flash drive, cloud, and so on and so forth. And you will mention the make and model, you will mention the color, the serial number, you will mention more details of this cloud ID, MAC, UID, and all of that, and any other relevant information. And you will say that if any about the digital or device record, and you will specify other things also there. And you will state that the hash value of this record is so and so, and it is obtained through the following algorithm. So here is a person himself giving a declaration in the first part of the certificate, has given a schedule which is annexed to the evidence and new Bharatiya Sakshi Adhiniyam, and the latter part is where the expert says that it is a proper record and which is not tampered. So it kind of gives authenticity to this electronic and digital record. So any concerns with regard to that, that should be put to rest, I believe, with the certificate being in place as said.
Then one query on this.
Yeah, please.
65B of the Indian Evidence Act. So now what will be the new number, or it remains the same and the new number is given?
Yeah, new number is very much there. Often it becomes a little difficult to tell you, but I believe 65B has become 63 as such. And that very 63 is what we were talking just now. And a reference is made to that 63 subsection 4 clause C in that certificate itself. The first portion, that very thing is brought about in the form of 63. It's just a renumbering of themselves.
But the certificate by the expert was not there earlier. Now it is there. But definition of expert is not given. Who is an expert?
Yeah, that is there. But that will come along. Somebody who is experienced in that field was able to see this.
Hashtag they want.
Yeah, hashtag.
So that means the computer should be available at that point in time for hashtag.
Yeah, those things are very much there. And I don't see much difficulty there, because earlier also certificates were given. I wish I had got some certificates to show you, which were given in the past. And
Without expert hashtag.
yeah.
Suppose if there comes
who
any
is an expert, that should be spelled as the time passes by. And that would be in place. I don't see much apprehension on
But
that.
when the original gadget, whether it is the computer or whether it is a mobile phone, if it is lost, then the certificate will suffice.
Now see, it's a matter of evidence. Sometimes people try to manipulate evidence by saying it was not in my custody, it was not, somebody else has misused it. All that will be subjected to test. No? All that what you're trying to establish through your falsity, so you would be put in the box, and then be put on the record, and that would be demolished by the other side by exposing your life. And that is a matter of skill of the advocate, how he does it. And he would have to know quite a bit about this technology. Therefore, I advise all the budding advocates and even the advocates who have put in a number of years of advocacy like me, around 25 years. We also need to update ourselves, though I claim to know and I taught cyber law. But when it comes to technicalities, we do have to update ourselves and get to know a few more things.
Also, you know that we talk about sting operation, or we talk about every mobile has got a recording. Okay, but without the information of the recording, it was in the code of law.
Now see, there were cases in the past also where there was, what you call it, without the knowledge of the person you're doing
Sting operation.
Sting operation. There were cases, no? Court is looking at the truth of the matter. Now how it was done.
Merits.
What merits. Court would still perhaps entertain that as in the past. Because what matters is what is getting exposed. And that is the concern of the court. No? To bring justice. The truth should prevail. Truth whether got to this manner. But when it comes to cops, there is that section 27 of the old law, which is now perhaps revamped, and 27 of Evidence Act to tell you that if the accused under pressure, under coercion of the cop, if he says I've hidden the murder weapon at so and so place, the cop would take some punchers and go with him to that place. And if that weapon is found in that place, then that deposition or whatever the accused have said to the cop, that would be tenable in law. Only to the extent of the discovery made, pursuant to the confession made by the accused to the cop, not otherwise. Now, there were chances that that also could be manipulated to cop, perhaps. No, if you have to set your imagination, you could say that cop could be keeping that weapon there, just to put the blame on that fellow, and then thereafter taking him there. But today, that would have to be videographed, and it would be, what that would prevail us. Now, I wanted to bring to your notice certain other, I was talking about 27, that is renumbered as some 33 as said. No, but other, 27 of that whole act, how much of the information received. That is confession to police officer. Now it is renumbered at section 23. Of course, we are still to get conversant with this numbering as such. But as time passes by, I'm sure it will be much more easier to remember the section number than it was earlier, talking pro this new laws, because now they are put in a proper order. Just as I pointed out in Indian Penal Code, separate chapter is dedicated to women and children, so that you know where to look for. Now, definition also put in proper order, alphabetically, so that you are able to memorize also and know where to look for this. Okay. Then I was talking about that, I wanted you all to take a good look at that section 154, that FIR thing. I thought of keeping it for later, and therefore we will visit that section now. So 173 is a new number, and we will take a little more closer look at it, because I wish to say a thing or two since it concerns citizen. Now, the section, allow me to take you to a couple of lines at least. It begins by saying 173, the new number of earlier 154. It says, every information relating to the commission of a cognizable offense. Offenses where mostly the punishment is years or more cognizable. Irrespective of the area, which means that no matter where you are, you can send your FIR from wherever you are. Even though it is so, my appeal to you all would be, nobody has briefed me to do that, not as somebody urged me or requested me to say that. But I would say, why would you do that? If at all you are required to go within 3 days and sign that FIR, you might as well make it if possible on that very day. Now, this is a little bit of grey area, where it doesn't specifically say that the cop will have to swing into action as soon as you send that first information electronically. It doesn't say so categorically. But in my understanding, it is courts are called to pronounce judgment on whether he is required to act immediately. And for a cop also, he would perhaps not wait till 3 days for the confirmation of that person. He would act, he would have his own sources to know that such a thing has happened or not. And he would perhaps swing into action without waiting for that person to come within 3 days and confirm what is sent to electronically, and thereby try to book that person or do justice to the person. That is one grey area, or rather, legislature perhaps would have said, okay, let not a person be sent like in Lamington, there is an area. At a particular spot, a person could be sent to police station A or B or C. If it happens to such a spot where the police station would be, saying that not in my jurisdiction, not in my jurisdiction. But now with this, you are required to file it wherever, and then they would forward it to the concerned police. As a layman, you would say, उनको forward तो करना है, लेकिन record भी maintain करना पड़ेगा. If you know the right police station, why won't you send it to them themselves, so that they can do something about it, they can maintain proper record, and swifter action would happen.
There is also one particular issue here, that suppose you are staying in Bandra and you want to file a FIR in Bandra police station. It is a common thing that the FIR is not being lodged. But when you are having a jurisdiction of Bandra and you file an FIR online anywhere, from anywhere. So it will be much easier for the FIR to be lodged rather than personally coming and visiting.
You could say so. You are perhaps making this statement with some experience, bad experience in the past, where the cops may have turned you away and not entertained your FIR. Believe me, more often than not, it is so that the person thinks that a grave wrong has been done to him, but the offense that he perhaps is narrating to the officer on duty may not be that serious, may not be an offense for which cognizance should be taken, may not be an offense which should be reduced in writing. This may sound as if I am briefed by the police authorities to, take their side, but it is not so. There may be a case where really there was a case for recording an FIR, and that also I can say, because there are quite a few cases which are where the High Court has directed the concerned authority, police authority, to register an FIR where they are not registered. Okay. What you are trying to say perhaps is really good. Now, the legislature, let me look at it from your perspective and demonstrate how it is helpful to the citizen. Today, no way the cop can say you cannot register it. That's what you are trying to say. Right. And that is also correct. That is absolutely right. Once I've sent my FIR electronically, all that I've got to go and do is just go and sign it over there. Right. And that becomes the authentic FIR. Okay. So, to that extent, yes. No? But will everything, if I name something as an FIR, will it have to be, supposing I say he came and gave me gali, he came and gave me bad words, and I send a FIR. To a layman, I can't distinguish between a cognizable and a non-cognizable. For me, that was serious enough. Ma behin pe gali diya. I need to go and before I go to the police station, I'm so disturbed, so perturbed, I immediately shoot a FIR. Now there I go within 3 days and say, sir, this new number 173, the old 154%, you have to take my signature and that should be treated as FIR. Now what do you expect the cop to do? Will he register as an FIR, or you expect him to explain to you, look, this is only meant for cognizable offences, that we can arrest a person without any warrant, without any more ado. No? But your case is not such a case. Perhaps we can call the other side and help you all to, settle the matter. It could be that case. Those grey areas will remain. And there are chances that people may misuse. What happens, I'm saying, if the people flood a police station with n number of, to jam their system, n number of FIR, that would be, you're misusing. Legislature intended to bring about justice to you. It is trying to help citizens, and that very thing which was meant to help you, you're trying to misuse it, and you're jamming the system.
Well, it would be both ways. You either jam the system or you jam the citizens. By not accepting an FIR, it could be argued both ways.
Concern is addressed by allowing FIR to be accepted through electronic means.
And as you said, cooperation of all. Earlier you made the
statement. Is only jamming the system from the citizens. From the legislature, they have taken care of the concern of the citizen. Now it's for us to cooperate and...
Cooperation is the answer.
Yes, cooperation is the answer. Make that system work. No? And then there was always this provision in law as far as FIR is concerned, that if he doesn't take your FIR, which people don't know,
they can go
right to president, the right to prime minister, the right to governor, the right to CM and all kind of authorities, thinking that they would do justice. And with the result, they have wasted precious years in waiting for justice. Lack of information, lack of education, lack of awareness. If they were to approach the right authority, there are civil cases also when they have done this and they have gone beyond time limit. And the courts are helpless to help them with their legitimate right, because their legal remedy is gone. Right may not have got extinguished because of that thing going beyond limitation. Therefore, the law provides, it did earlier also, it continues to do so now, that if the cop doesn't take your FIR, you have to approach the superintendent of law. If he also doesn't take, then the courts are always open to those. That remedy remains, that remedy doesn't go away. In fact, the citizen is helped even more with the provision of this new provision as such.
The new BNNS.
New BNNS. Okay, Nagrik Suraksha Sanhita 2023.
So, if there are any shortcomings, the matter will go up to the Supreme Court, and D.K. Basu, Anish Kumar, you will get new guidelines also from the Supreme Court. So it is a matter of time. There may be some teething problem, but the intent is good. So let's hope that something good comes out. And law is always, It keeps on
Evolving.
upgrading.
And evolving,
Whenever
but
any
then
shortcomings are there, if the Supreme Court feels that these guidelines has to be issued, they will issue the guidelines. So let's hope that we create a better environment for our citizens of India.
There is one more thing. In the case of 498A, it has not been touched. Okay, but parallelly, if you see 377 IPC, that has been scrapped. So how do you look at it?
Yeah, that is one area which is spoken about. Earlier there was a 377. Then they said if it is non-consensual, then it is punishable. Then they said if it's consensual, it's okay. But finally they did away with that section altogether. This new law does not contain that 377 clause. Of course, the male section of the society, they may say, today if an offence is committed against a male person, where is the provision in law? Though some offences are made gender neutral, but which is not so with all the offences. That concern remains, but I believe with the passage of time that concern also would be addressed. And we are also mindful of the fact that we cannot deny the fact that there could be sexual offences against men as well. No? So that needs to be addressed. And as Sir said, Senior Advocate SULAIMAN, he said, some concerns may be carried to the court. Some may be politically motivated, and therefore you are carrying that concern to the court just to delay the whole matter. Courts will see through your strategy, I'm telling you. Because the court will take a holistic view of that new law. Court will not look at a particular provision in isolation and say, look, here there's a problem with regard to so and so. Court will see overall what they have done, what the legislature have done. Whether they have tried to do justice to all the sections of the society or not. Whether they have tried to address the concern of the citizen, when there was gang rape, when there was mob lynching, all the provisions are brought in. That is keeping in mind the outcry of the citizens over a period of time. So the court will look at it that way. And therefore, I won't be much surprised if many times you got to, court would land up telling you, no, this new law is fine. There's nothing you can do about it. And we find there's nothing wrong with this new law. You won't be surprised if the court does that. But of course, the court may clarify a little more with regard to some ambiguity which may have crept in the process of helping the citizen. That I'm sure court has always been doing in the past, and the Honorable Court will continue to do so in the future as well. I said even timelines with regard to death sentence. A person knows he's put to death sentence is about to it, but then within 60 days he got to do this, he got to be told. Then those who are not approached also, their concerns also be taken up by the Superintendent of Jail. More details are there, but if I start addressing those, taking out to it, it will take some time. But if need be, we can do that. Yeah. Any other query, please?
Only about the FIR, the query was there, so that you have cleared it up.
Yeah.
And about the 65B, so now the new section will come here. 63. So thank you, Sudha, for coming here and spending your precious time and giving us a very informed knowledge about the new laws and how to file an FIR online and within 3 days. Now everything, this is something new. So there will be a teething problem, but believe me, the court will come out with certain guidelines if there are any ambiguities being found or there are some things which needs to be smoothed up. So we hope for the better and cooperate. Now it doesn't, as he said, Ambedkar, Honorable Dr. Ambedkar said that the cooperation is needed. So the cooperation is needed from all the sides to be progressive. So I thank you everyone here, Mohammad Afzal, C. Amit Israni, and stay tuned to our channel for more updates on legal matters that affect you. If you find this informative, then like, subscribe and share with your friends and contacts for more engaging content on legal issues. See you again in the next video with a new topic. Till then, take care, stay blessed, be safe and remain healthy. Jai Hind.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. Knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with